Okay.
Hi, I am Jeffrey Wernick, and I'm very pleased to have as my guest today Randy Barnett. Randy Barnett is the director of the Georgia Center for the Constitution, and he has recently written, is this like your 12th or 13th book that you've written?
Yep.
And this is called A Life for Liberty, The Making of an American Originalist. It's a great read. Actually, I find I probably have read all or almost all of your books. You might find it strange that someone who studied economics is so interested in the law, but I've always been fascinated with the law. While I was at Chicago, I got to know pretty well Ronald Coase, and I would go sit in on classes taught by Easterbrook and Posner. I was very interested in law from this perspective of it's the infrastructure under which we as a society interact with each other. And also because I had planned on potentially one day being a business person, I thought that I would like to be able to understand contracts. So, because even today when I negotiate deals. I have my lawyer is in the room to, kick me under the table if I'm saying something stupid. But ultimately, I do not let my lawyer talk. I do all the talking, and I do even a lot of the drafting of the contracts. But then my lawyers review it and correct the numerous mistakes I make in the process. I've had some good. I've had, I love the word that I think, not only the word but the concept of liberty, and you say a life for liberty. I noticed that in the political process today, I saw in a recent speech, and I don't mean to make this political, that Trump gave, and where he talked about, I will make America this or that or whatever. No, the words liberty don't show up anymore in most of American political rhetoric. I know that in Kamala Harris, in her convention, there was some conversation about freedom. I think her perspective and definition of freedom would be significantly different than Milton Friedman's definition of freedom when he wrote Capitalism and Freedom. So it seems to be that as both a word that we use in our vocabulary and as a concept of a word that has some meaning and context, it seems to me there's very little interest anymore in the concept of liberty. So how do you find your experiences on college campuses and teaching? I think I read that 92% of academia is gonna likely vote for Kamala Harris. And again, I don't mean to make this as a political comment, but mostly people who don't believe in the perspective that you've talked about in your view of originalism. And I guess your view of originalism has been shaped to some extent by someone who's had a great influence on me. And while you might self-identify more as a libertarian, I'm quite overt about the fact that, and I know I've heard you mention that you have met Murray Rothbard. I have not met Murray. I met Murray Rothbard once briefly, but I knew Ayn Rand, and I was friendly with Hayek, and as you're aware, both Hayek and Rothbard basically wrote pieces explaining why they did not believe they were conservatives in the conflict between what it meant to be libertarian or conservatism. Maybe Hayek considered himself more of a libertarian, and Rothbard an anarcho-capitalist. So I consider myself an anarcho-capitalist. I think that once you introduce government, the possibility of even limiting government and preserving liberty, I think, becomes impossible. And I think the U.S. is a prime example of that. So as you've lived your life for liberty, and how do you think how good a job do you think we've done preserving liberty, and what can we do to continue to pursue life, liberty, and happiness?
Well, thanks for having me on the show, Jeff. I appreciate that context that you've just provided about your own views. That helps me a lot. And without getting political, I have to say I was very much amused then when former President Trump chose to address the Libertarian National Convention this year, and to mixed response by the libertarians in the audience, but some very supportive. And I think they should have been flattered that a major party candidate would come and try to solicit their votes. One of the lines he used there is, if I wasn't a libertarian before the last 2 years, I am a libertarian now, meaning the times in which he's been pursued by the government in various forums. So, you might want to say that a libertarian is a conservative or a populist who's been mugged by reality, the way they used to talk about liberals being mugged by reality. And maybe Trump was mugged by reality. So I'm not saying that Donald Trump is a libertarian. Frankly, I don't think he's all that ideological, period. And so that's one reason why he doesn't fit into any particular ideological box. But I do think libertarianism is important. It's something as I describe in my book, I've been involved with since I was a junior in college at Northwestern is when I first heard about it. Prior to that, I would have considered myself a conservative. I debated on behalf of Barry Goldwater in 1964 at the age of 12 years old in front of my entire junior high school and grade school student bodies in the gym. In the book, I actually am able to use the handwritten notes that I made for that debate and could reproduce my concluding argument at the age of 12, which I have in my own handwriting. So in my heart, I thought Barry Goldwater was right. And I believe what attracted me to Goldwater was his commitment to liberty. It was after that the libertarian movement really got started. And I became a libertarian in my junior year. And by my senior year, I was teaching a course on libertarianism, a seminar on libertarianism at Northwestern, a student-organized seminar. And it was then the next year after that, when I went to Harvard Law School, I'd written a letter to Murray Rothbard, a fan letter, which he then gave to another entering law student at Harvard, John Hagel, who at that time was the president of a newly formed organization called the Center for Libertarian Studies in New York. John took me down to New York that fall, and I met Murray. And by the spring semester of my first year of law school, I was asked to join the board of the Center for Libertarian Studies, which I did. And we organized the Libertarian Scholars Conference every year. And we had a scholarly journal called the Journal of Libertarian Studies. So I became very immersed in libertarian theory as a student, both an undergraduate and a law student. And I still am. In fact, my first monograph was called The Structure of Liberty, Justice and the Rule of Law, which is a very Hayekian, at least it starts off with a very Hayekian focus on the problem of knowledge before it gets into the problem of interest and the problem of power, which supplements what Hayek says. And I do think my next book after this one, the next book after this one is going to talk about my time as an assistant state's attorney, criminal prosecutor in Chicago, because those years I had to take out of this book because there were just too many stories that made the book too long, and it had to be a separate book called True Tales of Crime and Corruption in Chicago. But the book after that, which I'm hoping to start writing, I'm almost done with the criminal justice book, the prosecution book. What I hope to start is a new book on libertarianism in the spring, which will talk about how the libertarian model really needs to be updated, I think, or at least we need to think about it harder. And I talk about that possible direction in the afterword of this book of A Life for Liberty. I do talk about what's the future for libertarianism, what's the future for originalism, and also what's the future for Jewry, because ever since October 7th, American Jews, as well as Israeli Jews, in fact, Jews around the world have had to be concerned about our status and our safety in whatever country we happen to reside in. And I have a bit at the end of the book about that as well. So I think I've moved away from your question a little bit. I've given a little bit of my background, and there's a lot more to these stories that anybody who's interested in the intellectual history of libertarianism or the intellectual history of originalism, which is where I'm active now, might want to read this book because it's a first-person account of what these movements were, how I participated in them, and it explains them as well. It's just describing my role in it.
Where do you think you've made the greatest contribution to originalism?
Well, it was in promoting original public meaning originalism, which an idea I got from a man you know, Jeffrey, named
Yes.
Lysander Spooner.
Yes.
And because prior to that, I was not an originalist, in part because I accepted the criticisms that are made of originalism, that it was impractical to find the intentions of all the framers who had various different intentions. There wasn't one intention, and also that we should not be bound by whatever their intentions may have been. They're long dead and we are alive. And so for both of those reasons, I rejected originalism until I came across Spooner's book just by happenstance while I was teaching a seminar at Boston University on constitutional theory. There was a footnote that referenced Lysander Spooner, The Unconstitutionality of Slavery, and then it had a date of 1845. And all I knew about Spooner was his anarchist work, No Treason, the Constitution of No Authority, which I read in college, and which actually influenced me a great deal in my in questioning the legitimacy of the Constitution for lack of basic consent. That was what Spooner said, but I couldn't imagine what Spooner. First of all, I didn't know he wrote anything else besides that. Mm-hmm. Turns out he wrote at least 6 volumes of scholarship, because I have a 6-volume collected work of Lysander Spooner, which does not even include everything he wrote. And that's where this book was. It turns out I asked the library to get me this book. I didn't know what it was, a book or an article. It turns out it was a monograph. It was a 280-page book that was one of the volumes in this 6-volume work. And in it, Spooner was arguing against the radical abolitionists who claimed that the Constitution was a covenant with death and an agreement with hell, because the framers intended to protect slavery by what they wrote in the Constitution. And Spooner's response to them was, we are not bound by whatever they intended. We're only bound by what they wrote. And they didn't use the word slavery. They referred to it at best euphemistically. And each one of the clauses that allegedly refers to slavery was really have an innocent meaning. And Spooner adopted a rule of construction that basically said, when basic rights are at issue, if there's going to be a violation of rights, it has to be expressed with irresistible clearness before we'll assume that a document like the Constitution is meant to violate these fundamental rights the way slavery does. Now, I want to be clear to your audience, because I'm sometimes misunderstood. At the end of the day, after years of studying originalism, I have concluded that Spooner was wrong in his claim about the U.S. Constitution. I think the U.S. Constitution did, in fact, refer to slavery in the clauses that Spooner denied it did. But what I got from Spooner was the method, which is we're interested in even what Spooner called the original meaning of the text, not the original intentions of those or the motivations of those who authored the text. We're only bound by what they said and not what they did, and not what they thought or not what they intended. And I brought that insight out of Spooner in my first book on the Constitution, Restoring the Lost Constitution, into constitutional theory in 2004. And that was, I think, one of my singular contributions to originalism. The other one was to take a distinction that I did not invent. It's actually an age-old distinction, and one that another professor then at Princeton, now at Yale Law School, named Keith Whittington, put in his books, which is the distinction between interpreting the meaning of the Constitution, which is one activity, and applying that meaning or implementing that meaning when you apply it to real-world cases, which is another activity. He called the first of those activities interpretation, and the second of those activities construction. I took Whittington's distinction and combined that with original public meaning originalism to create what came to be called the new originalism. And it's that originalism that has come to dominate originalism or constitutional interpretation generally, not the framers' intent version. Every judge who identifies as an originalist, if you ask them, will tell you they identify as an original public meaning originalist. It's original public meaning originalism that responded to the criticisms of originalism and made it a defensible and an attractive theory.
Well, I find actually more interesting, and I host a regular podcast on PodShoot with Bruce Fine.
I know Bruce.
Points. And so this issue to me I'm also a Bitcoin person. I've been involved in Bitcoin since 2009, and an important concept embedded in Bitcoin is consent and consensus, and how consensus is formed is through this proof of work protocol. So for me, the issue of consent is a crucial issue, and is anything legitimate if we don't give explicit consent to. So can we live a life of liberty uh, in the context of what not only Spooner mentioned, but also in correspondence between Jefferson and Madison, the concept, and I like to remind people, Jefferson did not directly participate in the Constitutional Convention. He was overseas at the time. That Jefferson thought there were several flaws to the Constitution, and one of them was he thought that the Constitution should have a finite life to it, because he thought that it was not legitimate if people were bound by it who were never part of the process of actually consenting to the agreement. And he said the same thing about debt, that debt should be paid off over by 16, 19 years, as I recall what he mentioned. And there's the same thing with the life of the Constitution. For the same concept is that people should not inherit a debt that they never consented to, and so the people who consented to the issuance of the debt should be responsible for paying that debt off. Let me
just
add one other thing, and also the concept of then giving the last word, to people, through the ability of the act of nullification. So if you take a look at both, Lysander Spooner's criticism of the Constitution, in many ways not too dissimilar from Jefferson's, can we really separate out liberty from consent? And really, this document, the people who live under this document, have never really consented to live under this rules, because almost every other contractual arrangement is an arrangement where the parties that are subject to the arrangement have negotiated and consented to that agreement.
Well, in that book, Restoring the Lost Constitution in 2004, I do respond to Spooner's claim, and argue that there is such a thing called constitutional legitimacy that exists or does not exist without consent. I mean, you can have legitimacy without consent. And how is that the case? Well, let me just start off with a simple example. When I was a criminal prosecutor in Chicago, Jeff, I prosecuted people for murders, rapes, and armed robberies. And it did not matter that the defendant in a murder case had not consented to the jurisdiction of the Circuit Court of Cook County. What mattered is whether there was evidence of their guilt. In other words, what justified the prosecution of a guilty person, assuming they're guilty, is proof that they're guilty of a crime, and therefore they violated the rights of others. Their consent is irrelevant to that process. So I think the same thing is true of, or can be true of governing institutions as well. And so that you would be bound by law. Let's just talk about law. We'd be bound by law if you have reason to believe, or if there is good cause to believe, that that law is both not violating your rights and is necessary to protect the rights of others. You would have a moral duty to obey that law, a prima facie moral duty, because it could be rebutted by other circumstances that you might bring out. But at least to begin with, you'd have a prima facie moral duty to adhere to that law. For the same reason, you have a moral duty to respect the rights of others. If a law is necessary to protect the rights of others, then you have a duty to adhere to that law, because you have a duty to respect the rights of others, and that's irrespective of your consent. So this is a rights-based theory of legitimacy as opposed to a consent-based theory of legitimacy. I think where consent actually entered into the picture during the Revolution, and it's what the consent of the governed is actually referring to in the Declaration of Independence, is the American people deciding collectively whether they're going to be ruled by Great Britain or the United Kingdom, or whether they're going to be ruled by their own governments. It isn't a matter of whether you consent to each and every law that passes or that gets imposed on you, but whether people get to decide which government governs them. And whether or not that makes sense, Jeff, it's not the same thing as whether you and I have a duty to follow the law, assuming that law is made in such a way as to assure us that it's necessary and proper to protect the rights of others. Now, an illegitimate legal system is one that does not provide that assurance. That is, just because something's called a law doesn't mean it's necessary and proper to protect the rights of others. So in order to answer the question of whether any legal system is legitimate or whether our constitutional system is legitimate, first you have to figure out what the Constitution says. And what the Constitution says is its original meaning. That's a description of what the Constitution says. And then you have to ask yourself, based on what it says, if it's followed, does it create a legal system that basically says the quality goes in before the name law goes on? The quality that this law is rights respecting and rights protecting goes in to the legislative process before they call something a law. If you have that confidence in our lawmaking process, then a law can be prima facie valid. A system can be prima facie legitimate, even without consent. The problem here is twofold. One is our lawmaking process, at least the one that's in the document, good enough to provide this legitimacy? You can answer that question however you wish. I think it would be, by the way. But secondly, is that lawmaking process actually being followed? Is the Constitution being followed? And I think it's not been followed. It hasn't been followed for quite some time. And therefore, it's an open question whether the government we have is legitimate as opposed to the government we would have if they followed the Constitution.
Well, how can we live a life of liberty if people don't follow the Constitution?
Well, I mean, I do think
including the Supreme Court. The Supreme Court. I've heard in several of the other. I was listening to some of the other recent podcasts that you've done, interviews you've done, and I know that you seem to have been given, reasonably decent grades to this existing court as being people who at least describe themselves as public, meaning originalists. I would think that some of the most important rulings that they made, in the last year or two, especially with respect to the relationship between the various branches in our systems of checks and balances, and I refer to the cases of both Trump v. Anderson and the Trump immunity case is. I don't find any words in the Constitution, and I don't think they even made any reference to any citations that seemed to be an outcome-oriented decision. It was, in my opinion, an activist decision. So if the people who might be our role models for public meaning originalism, are only committed to it when they like the outcome that will produce, and are not so committed to it when it doesn't produce the outcome they want to produce.
Well, let's take that up, because that is a common criticism made of originalism by non-originalists, especially by progressive non-originalists. It's a very common criticism we have. So the first response, the first step of a response is to say that originalism is not self-enforcing. Originalism is a theory that does not apply itself. It is a criteria. If it's valid, it's a criteria of what appropriate constitutional reasoning is and what inappropriate constitutional reasoning is. It provides a standard, in other words, against which you can judge constitutional actors, be they legislators, executives, or judges. And so if originalism is valid, and I'm just assuming that now, if originalism is valid, it's useful as a means of assessing whether the Supreme Court has acted in a manner that's consistent with the original meaning of the Constitution. Your claim, which I don't wish to debate today, and I'm not prepared to debate today, is that in the immunity case, they were not doing that. They certainly did not offer originalist arguments in that case. That's for sure. So there's two senses in which a decision of the Supreme Court might or might not be originalist. One is if they use originalist reasoning to reach their result. I think we can fairly say that if they use originalist reasoning to reach their result, we'd call that opinion originalist, even if we think they've made a mistake, even if we think they've done it incorrectly. So, for example, the Heller case, which recognized the individual right to keep and bear arms, the original meaning of the Second Amendment protected an individual right to keep and bear arms. I believe that was correctly decided. But even if you think it was incorrectly decided, you would say they did use originalism. It was an originalist opinion by Justice Scalia. So that's one sense. Do they use originalism? There's another sense, and that is the outcome they reach consistent with the original meaning of the Constitution, even if they don't use originalism? Now, we can all reach our own judgments about that. I think there's lots of things they do that they don't use originalist lots of things the court has always done that they don't use originalist arguments to do, and yet they're consistent with the original meaning, or maybe they're inconsistent with the original meaning. There is a problem of judges doing this, that is, reaching arguably originalist results without doing the originalist work. And that is what I call, it's off the books originalism. They have an originalist theory in their head about what the right answer is, but they don't actually lay it out for us the way Justice Scalia did in Heller. He laid it out in Heller, subjected himself to criticism, and maybe he got it wrong. But in the case of a non-originalist reasoned opinion, they don't lay it out, even if in their head they think, well, what we're doing is consistent with originalism. Or we can say what they did was consistent with originalism. So there's these two different senses. So I guess I just want to go back to my first point and emphasize it. Originalism is not self-enforcing. It is a criteria by which you judge whether a judge or another constitutional actor is acting properly or improperly. Let me give you one more analogy. We can say that there are such a thing as natural rights that require protection in order for human beings to flourish while living in society with each other. But natural rights themselves are not self-enforcing. Natural rights can be violated. What natural rights do provide is a criteria by which we can evaluate somebody's conduct to say whether it's rightful or wrongful. And if it violates the rights of others, we say it's wrongful. And if it doesn't, we say it's rightful. But the concept of natural rights doesn't stop them from acting unjustly. Neither does the concept or method of originalism stop judges from acting willfully if they don't follow the method. So that would be, I think, a more constructive way to view what the appropriate role of originalism is when we think about the Supreme Court.
I personally think it's really hard to separate out, given the fact that words are subject to the ability to write. A lot of words are purposely ambiguous because there isn't really a precise consent to what those words mean. So they're written with intentional ambiguity, so that because it's a reflection of the fact that there's not always a consensus on agreement on words. So the final words end up somewhat ambiguous in nature. So given the fact that words are subject to construction and interpretation, and ambiguity isn't like in contract law. If I write a contract, you and I negotiate a deal and we sign a contract, and some third party who was not a party to the contract says, I'm not sure, I'm trying to figure out what these words mean. And you're saying, well, to me, those words mean one thing. And I'm saying, to me, these words mean another thing. Then they're going to go look back and they're going to look at what were the intent of the parties when they put those words together. And they're going to look at the negotiations that led up.
That's actually not what they're going to look at. I was a contracts professor before I was a constitutional law professor. And that's not what they're going to look at in the first instance. In the first instance, they're going to look at what the reasonable meaning of the words are.
Right.
And they're going to side with whichever party is asserting the reasonable meaning of the words as opposed to an unreasonable meaning. In other words, it's the same thing as public meaning originalism. What would these words mean to a reasonable person? Now, it is possible in the contract sense, case, if you can show that both parties actually had used a word in an idiosyncratic way, if that can be proven, they both understood that word in an idiosyncratic way, then the idiosyncratic meaning will govern. That there is where you're right. But if each party associates a different meaning to the word, one meaning is idiosyncratic and one meaning is reasonable, the courts will side with the party that held the reasonable meaning, not the idiosyncratic one, if there's disagreement between the parties. Now, going back to the Constitution, the framers of our Constitution, the drafters of our Constitution, tried really, really hard to avoid ambiguities. Ambiguities are terms with more than one meaning. Like the word arms could mean weapons, or it could mean the limbs to which our hands are attached. Which is it? Well, in context, it's clear that in the Second Amendment, it's referring to weapons and not to the limbs to which our hands are attached. They tried really, really hard to avoid ambiguity, multiple meanings. They didn't always succeed. It's not clear that the term direct tax, for example, had a singular meaning. It might have been ambiguous. However, where they did deliberately use ambiguity was when they were referring to slavery, which takes us back to the beginning of our talk.
Right.
When they referred to slavery, they chose euphemisms. And euphemisms are a deliberate attempt to use ambiguity. They're using words that have an innocent meaning to suggest a guilty meaning. Words have different meanings. Words would allow for both meanings. Now, my own view is that notwithstanding their use of euphemisms, and the reason why I think Spooner was ultimately wrong in his defense of the Constitution on that score is that when the context reveals that the public meaning of persons held to service was slaves, was enslaved people, and not indentured servants, or it was both enslaved people and indentured service, if that's what the context suggested to the general public, then that was the original meaning, even if they intentionally used ambiguity. And the only time ambiguity becomes a problem is if it's irresolvable, if there is no reasonable meaning that it could have been. And then again, some people have claimed that the term direct tax in the taxation clause is an example of where, for example, northern states had one conception of what a direct tax was, and southern states had a different conception of what direct tax was. And when they put that term in, they actually never resolved that ambiguity. But that example is extremely rare. Now, I do think what you probably are thinking about is not ambiguity. What you're probably thinking about is vagueness. Vagueness is a different characteristic of ambiguity is more than one meaning. Which is it? That's almost always resolvable by historical evidence. Vagueness, however, is not always resolved by historical evidence. A vague term is a general term in which there may be paradigm or core examples of what that term refers to. And then there are some core paradigm examples of what it does not refer to. But in between those two classes are situations where it's not clear whether it applies or it does not apply. There's what they call a penumbra around the core. And in that penumbra, it's not clear. So whether something, for example, is hot or cold, you might say things, well, there's some things that in certain contexts are clearly cold. And there's some things in certain contexts that are clearly hot. But at what point does cold become hot? In the middle, it's vague. Now, there are general terms in the Constitution that are vague in that way. And that's where constitutional construction is allowed and required. So there I agree with you. But there is less vagueness in the Constitution than than's commonly claimed by people who want to find a lot of vagueness to give them a license to do what they want to do. If you do historical analysis, you're going to find less vagueness than people say there is.
So I guess to agree with this point you're making, I'd have to say is that if you spoke to the 9 justices on the Supreme Court, they all would agree on what the meaning of, if they all adopted the concept of public meaning originalism as the way they made their opinions, that they all basically would write similar opinions and come to unanimous decisions if they all adopted that rule, because if the words lack ambiguity and lack vagueness, then they should all reach exactly the same conclusion, because the words are so clear and they're applying the same principle that they basically should all get to the same result for the same reason.
Well, most courts do get to the same result for the same reason. The cases that go to the Supreme Court are unusually contentious ones. Right. And so it's sort of there's a selection effect. There's a selection bias problem. Potentially millions or billions of claims are never brought because they're clearly outside the permissible boundaries established by the Constitution or the laws passed thereunder. Mm-hmm. But in the course of applying law to individual people start raising claims. Most all those claims are relatively easily resolved at the lowest level of decision makers, the trial court level. Sometimes it'll get to the Court of Appeals. And it's when the Court of Appeals themselves are disagreeing with each other. It's called a circuit split, When the circuit courts don't agree with each other, then the Supreme Court might step in and try to resolve that case. But now you've filtered out all the easy cases, and you've produced 130 or so very difficult cases. And most of them, frankly, don't involve constitutional interpretation at all. Most of them involve interpretation of statutes, right, which themselves create problems of application and ambiguity and vagueness. So I do agree that when the hard cases come up, reasonable people are going to disagree. But generally speaking, the Supreme Court is not doing original meaning. And this goes back to your earlier point, Jeff, which I kind of do agree with. And that is that a self-professed originalist doesn't mean they are always going to be doing originalism the way they should be. I was agreeing with you when I said originalism provides a standard against which we can judge them. I was agreeing with you that they don't always live up to that standard. And only 5 of the 6 conservatives consider themselves originalists anyway. Chief Justice Roberts does not consider himself an originalist. But those that do, they've given themselves ways to get out. They give precedent, for example, is a way that Justice Scalia always used to get out of originalism if he didn't want to deal with originalism, the original meaning. So it's absolutely right. They can escape from it. And ultimately, we can't stop them, but we can criticize them and we can shame them. And they try to avoid being criticized in that way.
Do you think some of the proposals and suggestions that made, so given the fact that how legitimate is the Constitution itself then, if it's constructed, interpreted in a way that's inconsistent with the text that has been consented to, and that future generations have been bound to that consent, and is being changed in a way different than what the document itself says how it should be changed?
Well, I said earlier,
is any change, what recourse do the people have to preserve their liberty when they've consented to a document as they consented to words, and they said, okay, these are the words we consent to, okay? And then basically courts say, you know what, we read these words, we understand these words, we don't want to be bound by these words. They never say that. Well, the living originalists, that's basically
even they won't say it. I mean,
they don't say it, but they behave that way.
Some professors will say it. Yes. The judges will never say that.
But the reality is,
hypocrisy is the homage that vice pays to virtue. So they won't say that because they know that will not go down well with the public. I mean, I answered. I basically
understand the point I'm making, though.
Yeah, and I answered it earlier, and that is, I said that I think the Constitution, if it was followed, would establish a legitimate form of government in which laws are necessary and proper to protect the rights of others. But the Constitution has not been followed for some time. Now, the secondary question is, what do you do about that?
Correct.
So one of the things you do about that is you create a social movement to try to change the makeup of the Supreme Court so that the Supreme Court will start adopting what you consider to be the correct reading of the Constitution as opposed to the incorrect reading. Now, that is what the progressives did when they supplanted the more conservative justices in the 1930s over a long process that started with Teddy Roosevelt, who appointed Oliver Wendell Holmes Jr. to the court. It continued through Herbert Hoover, who appointed, for example, Oren Roberts to the court. And then it continued into FDR, who appointed a whole bunch of people New Dealers to the court. And it was over a period of decades, they achieved a Supreme Court that essentially threw out what the previous court was doing. And I tend to more sympathize with what the previous court was doing. And we got the New Deal justices, and then we got the Warren Court justices. And where some political conservatives disagreed with that, they began a political movement in order to try to affect the outcome, affect the composition of the Supreme Court and adopt what they thought was the correct way of approaching the Constitution, which was originalism. And so the Federalist Society for Law and Public Policy was established in the 1980s and eventually has become a very influential organization. And eventually we had a President Donald Trump, who pledged to appoint originalist judges or justices, in particular to replace Justice Scalia for an open seat that was made when Justice Scalia passed away in March before the November election. And as a result, he made 3 appointments of 3 people who identify as originalists. And that's a way of moving the court back in the direction of what some people think is the legitimate one. I think it's the legitimate one. Others don't agree. They were with the progressives. They thought that was the legitimate one. So that's what people do. You ask what recourse people have under our system. That is what recourse they have under our system. It's worked in both directions.
Are you a believer in nullification rights?
I do not believe that states have the right to nullify, or have a power is the actual phrase. I don't believe states have a power to nullify federal laws unilaterally. And James Madison agreed with me. In 1800, he wrote a report in which he discussed nullification, and he was defending the Virginia resolution that objected to interpretations of the Constitution by the Supreme Court and by Congress. And he denied there was an actual legal power to nullify. Jefferson was more ambiguous on whether he thought there really was one or not. I don't think there was one. I disagree with Tom Woods, for example, who thinks there was such a power of nullification. I did, however, propose a constitutional amendment, which got introduced into both houses of Congress. And I have a chapter in my book, A Life for Liberty, the Making of an American Originalist, in which I discuss the repeal amendment that I drafted and which was introduced in both the House and the Senate. And that constitutional amendment would have given a supermajority of the states the power to negate or nullify any federal law or regulation if they could agree to do that. It did not go anywhere after it got introduced because we didn't have any money. We didn't have enough money to promote it. We needed dark money to promote it, and I couldn't get any dark money. And so it died. It kind of died on the vine. But it was a way of giving states a power they don't actually have, which is a power to nullify, but only together with other states, not unilaterally state by state, but a supermajority of states, I think, should have a power like that. I think we'd be better off if they did, if we had that power.
Why do you believe in that the state should not have it, but the state should have to create not even a simple majority, but have the test of the supermajority of nullifying?
I think you could go, I could go with a simple majority, I suppose. I mean, I was trying to come up with a language that would be politically feasible. The easier it would be to do it, the more objections you get to having such a power. So that was what I ultimately proposed. And I still think it's probably a good idea to keep it as a supermajority. But you see, there's an example of where reasonable people could disagree about what's prudent.
Yeah, in reading some of the correspondence between Jefferson and Madison and their later correspondence, it seems to me that Jefferson was pretty unequivocal about the rights of nullification, and Madison was not completely against nullification.
No, he was
for a bunch of other things to be tried first. And if they failed, that nullification was the last thing. Jeff,
I have an open mind. I have an open mind. If you want to send me that evidence offline, I'll be happy to look at it. Madison was in favor of what he called interposition. And interposition is where the states interpose themselves between the people and the federal government and articulate an opinion on behalf of their people that what the federal government is doing is unconstitutional. But Madison said they have a right to do that for the same reason the people have a right to object. It's a matter of free speech. It's not a matter of juridical effect. He denied it had a juridical effect. It did have an important symbolic effect and a persuasive effect. Now, you also know, of course, that only 2 states issued such resolutions, and the other states passed resolutions condemning Virginia and Kentucky for their resolutions. And that's the reason why Madison wrote his report of 1800, because he was defending the justice or the legitimacy of having done the Virginia resolution in the first place.
Yeah, I will offline. I will look through, because this was correspondence between them that was more than 10 years, more than 15 years after that. So,
well, I do think Madison became less enamored with nullification as time went by, as he could see the threat of secession and the threat of a dissolution of the Union became a meaningful threat that concerned many of the founding fathers by the time the 1830s rolled around. And I think I'd be surprised by such evidence, Jeff, but I always have an originalist. I mean, an intellectual generally, but also an originalist always has to keep an open mind to the existence of evidence that they were not familiar with. And I do have an open mind.
Okay, well then I'll try and find the citations, and offline we might have a further conversation on that. So I mean, because I think for me, that's why I really appreciate you living a life of liberty and for liberty, is the fact that for me, I think that's the I think in a natural law paradigm, I think it's the right of every individual, every human being to be live a life of liberty. I think a number of justices from the Supreme Court said, the ultimate right of every individual is the right to be left alone. And so I think as long as there's nothing that we're doing that has a direct harm to somebody else, that ultimately we should be left alone. And I think if you take a look at the if we take a look at how if we take a look at thinking about being a Jew, if we think about God, well, for Jews really we were subject to 613 laws, but basically in the Bible, the minimum obligation for a civil society is to live under the Noahide law that predates the Ten Commandments, and there are only 7 laws. So basically, God basically said, if I want to construct a civil society, you don't have to believe in me, you don't have to believe in the Torah, you don't have to believe in these 613 commandments that I put up. Only Jews have to live by that, but at least everybody else has these minimum obligations, and they're basically 7 of the 10 commandments. So God was able to figure out a way of basically saying for a civil society, you only need these 7 laws. It seems to me, for people who basically say they live in a God-fearing society, they seem to require a lot more laws than God required. And I find that kind of ironic that so many people who are self-professed to be, have these religious beliefs, basically think that we need a lot more laws than God said we needed to have in order to live peacefully and harmoniously with each other. So, so it seems to me that, if we go back to natural law, and maybe the closest thing, and I don't mean to have a theocratic perspective, is that I think that maybe the closest thing to a natural law, is basically, outside of the provisions that related to man's relationship with God. And you just look at man's relationship with man, that basically, the most libertarian legal code, is the commandments that are completely unrelated to our duties and obligation to God, but our duties and obligation with respect to ourselves, which pretty much can be summed up with: don't commit violence against other people, and don't covet what's not yours. And that's, maybe you can say it's unnecessary to have to respect your parents. So maybe you can throw that one out, and maybe it's not required to have a legal obligation to respect, your parents, and nor honor them if they don't deserve to be respected and honored. But outside of that, it's just pretty simple. The rules are pretty simple, and we have so many rules that are significantly beyond the scope of one person causing harm to another person against their will. And if we have so many laws, then we're just trying to control people's behavior we don't like. That doesn't necessarily impair on our own liberty and our own sense of liberty and our own self-sovereignty, but just because we want to control people because it's convenient for us, because we like it and we think it's right, and we don't care about somebody else's rights. We care about coercing them to behave according to the standards that we think are the appropriate standards.
I tend to agree with all that.
So how can all of us, if I would have known you, I probably would have had a conversation with you about giving you some money to, continue to pursue the amendment if I felt that, giving money would give it traction, I would have had a discussion with you regarding the supermajority requirement, because I want it as easy as possible to usurp authority. So I don't want to create barriers to entry. I want to create barriers to entry to people exercising authority, not for people to challenge authority. So I want to make it easy for people to challenge authority, and I want to make it really, really difficult for people to. When I started my first company, I was so I didn't like the idea of hierarchy, of organizational structure. You get people together, and you have to have organizing it, but being Hayekian. And I started my first business when I was 23 years old.
What was that? What was that business, Jeff?
Risk management company. I built the first. I was everybody has their not everybody. Some people have their moments of fame. I was considered at one point in time the person for risk management for financial institutions.
Oh, I thought for a second you said waste management, which is what the business that Tony Soprano was in.
Risk management. No, Volcker had me speak at the. Actually, Milton Friedman advocated my model, and I didn't let him. He gave some talks to some people about my risk management model, but when it came to he wanted to become like he asked me about it if he could be like on my advisory board to help promote it. I said the problem with that is if I'm successful, you're going to claim I'm successful because of you, and I want to be successful because of me.
Good move.
I actually turned him down.
Good move.
I wanted to be successful because of me, not because of him. So, but
that was smart.
Volcker had me speak at the Fed. Several Federal Reserve banks had me speak and give workshops on risk management. So I built the first duration-based asset liability model, and it also had option pricing theory to price credit risk. So it was way ahead of its time. It was very different than I wrote this in like 1981, so 80, and it was after the beginning of the deregulation of the financial system, and we had double-digit inflation and double-digit unemployment, and banks, and we had an inverted yield curve, and banks got to be deregulated at a very difficult time, and they didn't have the talent to understand how to really manage a new risk that they had no experience with. So it was just a topic I had interest in, and I built the company around it. I had no idea how to run a business, but I know I didn't want to manage people, but I had to have people because I can't do this by myself. So I said, how do I use incentives to organize that people, rather than me actually give instructions to manage people? How can I build an incentive-based structure? So, the first person I had to hire, and then the second person, hired all the other people. And basically, whenever anybody came in, they had to be interviewed by everybody in the company. If one person said no, the person didn't get hired. Everybody had the same, veto rights. I was the last person to interview anyone, so nobody could call me up and say, "Hey, Jeff, you know me, can you get me influence?" No, I said, if you ever call somebody up and use my name, they're going to be hanging up the phone on you and say you can't get interviewed, because I didn't want anybody to feel coerced by making any decision, and I would give my judgment last. And ultimately, I never vetoed anybody. So, whoever people wanted to hire and whatever they wanted to pay them, I was okay with. So, and for people to get fired, there was a rotating board of directors, and they would make, important decisions. Everybody got to be on the board. I'm talking about even, the receptionist was on the board. So everybody, because I expected everybody to be treated with equal respect. There were no meetings where I had private meetings where I spoke to an individual. Every discussion, there was a topic, and we'd have a conference room, and everybody would be involved in the decision-making process. So for me, I wanted to demonstrate that you could be a self-organizing company, in the absence of any real controlling authority. So, I sold the business for a lot of money, less than 2 years later. So, I would say the experiment, worked out pretty well. I think the challenge in doing that is you have to, for people who are type A personalities, you have to be able to suppress your ego and not think of yourself as being that important. And actually, I didn't take a salary. I started off taking a salary, and then after a few months, I decided not to take a salary, and I basically auctioned off blocks of my time. So I basically told my team, if you used me, I'm setting a minimum price. This is this is the minimum price I set on my time. And if you don't think I'm worth it, there's no need to talk to me. So if you think I'm worth it, you'll pay me, you'll bid for it. And if at least the minimum price is set, then I'll spend the time. And it made them really make effective use of me, because I became a scarce resource, and they got me involved in things that were important to them, and they didn't get things involved that were not that important to them. So, for me, people exercising liberty has been, I never signed confidentiality agreements. I never signed no non-disclosure, no non-competes. If I couldn't retain somebody, if my obligation was to provide a workplace that people liked working at, and if people wanted to go and steal all my code and promote themselves, I didn't stop it. So nobody did it, but not because they didn't have a right to do it. It's because they liked working, under those circumstances. So I didn't need to put all these other protections in because there was no coercion involved in the relationship. So I mean, that's what I would like to see as a society. To me, that's what liberty means. Is liberty means an absence of coercion. In wrapping this up, why don't you describe what liberty means to you? And why don't you tell the people who are watching this or who might watch it later what liberty means to you? And what do you think we need to do to create a society where there's significantly more respect and all of us can live in a state of liberty?
Well, I do think that as human beings, we have natural ends, and that we strive to actualize our potential the way you did and the way you have done as an entrepreneur. You had potential, and you strove to actualize your potential, which is the definition of human flourishing, the actualization of one's potential. But to do that requires liberty. Liberty is an essential means to actualizing one's potential, because one has to make all the relevant choices that go into living a virtuous life to actualize one's potential. A virtuous life is not virtuous if it's compelled. If you're not a virtuous person, if somebody puts a gun to your head and say, do this, do that, do the other thing, that doesn't make you a virtuous. You might be doing everything that you're supposed to do because you're being coerced, but it doesn't make you a virtuous person. What makes you a virtuous person is you've chosen to do that. And in fact, you have habituated yourself to be doing the right thing to the point where you don't even need to think about it. You'll just do it. When you walk into a store, you don't think, well, I better not take anything because I might get caught. You walk into a store, it doesn't even occur to you to take stuff because you know it's not yours. You're virtuous in that respect. Right. So virtue is, I think, is what it takes. Acting virtuously is what it takes in order to pursue the good life, to actualize one's potential. And liberty is absolutely essential to that activity, to the activity of living one's life. So that's one of the reasons I think libertarians need to be clearer than they sometimes are about why liberty is a value. It is an inherent value. It is a necessary value, but it is a value that's a means to the higher end of human flourishing. And then what we need is a structure within which each person can act in such a manner as to to actualize their potential while living in close proximity with others. And that's why we need both natural rights, which is what separates us and which gives us our choice set. It defines a boundary within which we can act virtuously, and a boundary that we can't go into the next person's boundaries where they're having to pursue their good life as well. And then I think we need a legal structure in order to protect these rights. Now, whether that is a constitution or whether that is a government or not is an open question. But in a world that does have governments, and I think we'll both agree we have a world that has lots of governments in it. Right. I think these governments are best organized by a constitution that is designed to protect the individual rights of each and every one of us. Each and every one of we the people has an inherent right to live the good life. And our rights need to be protected by our government. It's the reason why the government is there, whether we consented to it or not. It's still the only justifiable reason for it to be there. And so I have decided, as a matter of, I would say, tactics, to pursue constitutionalism in the American context by talking about the American Constitution. If I were living in a different country, like Israel, for example, they have no written constitution.
Right.
I might have to be doing something quite different than I'm doing here. In Great Britain, they have no constitution. I just 2 years ago, I debated at the Oxford Union as to why they should have a codified constitution. You go look up YouTube, look up Randy Barnett and Oxford Union, and you'll see my debate about why they should codify their constitution. But I would make different arguments in our society, in our country. I think I thought that my best shot was to talk a lot about the Constitution and how, if properly interpreted, it would protect the rights of us each from each other, and thereby secure the liberty of we the people. As opposed to just writing philosophy papers or political theory papers and talking to other professors, it just seemed to me that this was something that would be useful for me to do. And I'll let the people be the judge. If they read my book, A Life for Liberty, I kind of make the argument for why I think my life was, my strategy was worth pursuing. And if people, especially younger people, are thinking about how they should live their lives, they might want to look at my book, because it gives an example of how somebody who came from Calumet City, Illinois, from a non-intellectual, neither of my parents had graduated from college. I didn't, when I was in Calumet City, Illinois, which is on the south side of Chicago, and I got my SAT scores, my high school guidance counselor said, well, with the scores like that, you could get into Northwestern, which is on, as you know, on the north side of Chicago in Evanston. Right. And as a boy in Calumet City, I said, oh, really? Where's that? Because I had lived such a sort of sheltered, or at least isolated life, that I didn't even know where Northwestern University was located. But I went from that to where I am today. And, you know, the great Jeffrey Wernick is interviewing me for his podcast.
Not very great.
I've come a long way. And this book is sort of a how-to manual if you want to live an impactful life. And if you want to live a life for liberty, look, here's my example. And I confessed my errors along the way. I made quite a few mistakes, and I'm quite candid about those mistakes that I made along the way. Don't make the mistakes I made. But here's some of the things you should do. And I think this would be, I wrote this for my grandchildren, but I think it would also serve any young person who wishes to live a life for liberty. Here's one way you can go about doing it.
Well, to express my thanks and appreciation for you, doing this interview with me. And what I would like to offer for those that are listening is, if they can write into BitChute, the first 10 people to write into BitChute regarding who can provide enough information. I don't want to collect information on people, but enough information for people to, which I think is minimal, for me to give them the Kindle version, because this is in Kindle form, that for the first 10 people that I guess write to Johnny at bitchute.com, JONNY at bitchute.com, the first 10 people that write in requesting a copy and give the information for me to gift them a Kindle, I will gift 10 copies of your book out to people.
Well, thank you.
As a thank you for participating in this.
I really appreciate it. In fact, I've probably done about 15 podcasts about my book, and now I'm going to make it a condition of future podcasts that everybody does what you just did. You've invented a new model for me to pursue as I do future podcasts.
I'm glad I might have done something good during this call. Can I ask you, and maybe this is more time that you want to. I know in some of the recent things I've read of things you've written, you've criticized libertarians to some extent for not adequately considering not only state power but corporate power, and I think that's something I assume you're going to address in this new book you're writing.
Correct.
After you finish the one on your experience in Chicago as a prosecutor. Are there any parting words or thoughts you'd like to share, or it's too long a topic and should be discussion of another pod shoot or any other place you choose
Yeah,
to.
I think it would provoke you, Jeff, and then we would be off and running. It is something I'm just thinking about. I do talk about it at the end of the Life for Liberty and the afterword, but I write books to figure out what I think. I only write books secondarily to influence what other people think. And so, because I actually haven't done the work yet, it's premature for me to suggest what I think should be done. Only that if we live in a world where, for example, all of our speech is taking place on non-government platforms, even that includes our cell phones, by the way.
Right.
If all speech is is taking place on non-government platforms, then I think we need to be concerned about the threat to liberty that non-government platforms or non-government institutions can pose to liberty, that we have protections against the government from doing, but we don't have protections against non-government organizations from doing. But it's a difficult problem. Getting government involved in things always makes things worse and not better. And so one needs to be cautious. But it is something I think libertarians need to think harder about in a world where more and more of communications is being handled on privately owned or non-governmental communications platforms.
Yeah, one of the things, at least I tend to not use these interviews to plug BitChute, but one of the things that you might be unaware of, I remind people, is that BitChute has there's no algorithmic manipulation of any content. BitChute's terms of service pretty much is the First Amendment, except with the exception of prohibition on pornography. And this is an adult-only site, so this is not a site for kids, but for people, I think 16 or 17 and older, and no pornography. But outside of that, if you basically have a phenomenal right to say something, BitChute doesn't interfere with the right. You have freedom of speech. You have freedom of reach. All the engagement is organic in nature. We back up our commitment with the fact that we don't even have a technical capacity to even throttle content, and we have a $10,000 bounty out there. If anybody can try and demonstrate that they were shadow banned, we'll pay them $10,000, and we know we're never going to pay anybody $10,000 because we don't shadow ban. So BitChute is a place where liberty thrives. Unfortunately, many people don't like the consequences of liberty because you see content out there that people really don't like, and they don't want to be affiliated with it. But there's a difference between choosing not to affiliate with it, and trying to mute the person from being able to express themselves. And I don't think we would need a First Amendment to protect speech that we like and that we want to hear more of. The purpose of the First Amendment is to protect the speech that we find offensive. So people don't seem to understand, the nature of the First Amendment and who it applies to. And it doesn't really, we don't have to practice this, but I think that the best way of promoting, with at least some of my personal capital is of promoting liberty is to promoting liberty through a platform where people know that that the narrative is organic in nature. It's not that we're writing an algorithm where people are putting up a lot of content, but what people see ends up the narrative that we create, rather than because that's just a lying ledger. So it's not telling the truth of the content being produced. It's showing it's acting as an editor to show people what you want to show and obscuring things you don't want people to see. And then you're making the choice on behalf of everyone rather than people making the choice on themselves. So this is what BitChute represents. And so you believe in living a life of liberty, and part of that life of liberty is being on a platform that shares the values that you so articulately express and have committed and dedicated your life to. And I strongly encourage people to read your book, and I'm going to contribute to at least 10 people that they get to read your book, and I hope other people will agree that interviewing you is worth at least the amount of money associated with buying 10 books, and you can get more of your work in circulation. and this would give people a lot of food for thought. It's really a great book. So I always like to get. I don't like to have the last word. So why don't you, whatever concluding words you want to be? I'd like you to conclude the podcast, not me.
Sure.
So
Well, thank you for having me. First of all, I'm going to look into BitChute myself. So that's one thing I'm going to do for you. And I appreciate your offer. And everybody who reads the book and likes the book, you should leave a 5-star review on Amazon. And if you don't like the book, then forget I said anything. Just don't leave any review.
Well, thank you so much.
Take care.
Great. Bye.
Thank you, Jeff. Appreciate it.
My pleasure. Bye.